People are still flowing in, but we'll just start doing introductions here, and people can join as they can. I just want to welcome all of you to the Dilworth IP Counsel to Counsel webinar series. Thanks a lot for joining us today. I'm Ben Lieberger, partner and attorney at Dilworth IP in Trumbull, Connecticut. Today we'll be talking about how the COVID-19 pandemic is affecting the practice of IP law in different jurisdictions around the globe. The entire world is going through the same thing right now with different levels of severity, and each IP office is addressing this in different ways. So the value we hope to provide to you today are insights directly from experts in key jurisdictions on how this is affecting IP practice, and hopefully help you make informed decisions about your global IP portfolio over the upcoming weeks and potentially months. You'll see on the bottom of your screen, so all the attendees are muted, but you do have a Q&A button on the bottom of your screen. So at any time during the webinar, if you'd like to submit a question, we'll probably hold questions until the end. But if things come up along the way, feel free to just type in a question there. The panelists will see it, and we'll take those at the end. If we don't have time to take questions, we'll get back to you anyway. We'll save those questions, or you can email me directly at the end with any questions. I'll get it to the right panelist. We'll also have a quick survey at the end, so we'd appreciate if you can fill that out. It'll just take a minute just to help us guide our future webinars. And this webinar is being recorded, so within a day or two after this, you'll all receive a link to download and view the recording and share with others. So we put together a great panel of experts from key jurisdictions to help us out today. Why don't we just go around the room and each of you can give a brief introduction here. We'll start with Eric Baumwe from Straumann Gulliksen in Sweden.
Hi everyone, my name is Eric. I'm calling in from Malmö in the southern part of Sweden now. As Ben said, I'm at Straumann Gulliksen working as a European patent attorney. I've been with the firm for 12 years now, and I really look forward to this webinar. Thanks, Ben.
Thanks, Eric. We also have Hans Chung from the Soe Patent Law Firm of Japan, although you're joining us from Virginia. Hey, Hans.
Hello everyone. My name is Sung-Yup Chung, but everybody call me Hans, so please call me Hans. And I'm working for a Japanese law firm called Soe Patent Law Firm, which is located in Tokyo, Japan. But we have an US branch office near Washington, D.C. area. So I'm talking from United States. I'm very excited to have this webinar today. Thank you.
Thanks, Hans. And next we have Deepak Parwar joining us from Strat Juris in India.
Hi everyone, this is Deepak Parwar from Strat Juris Law Partners India. I am a partner and a patent attorney with Strat Juris Law Partners with background in electronics and communication engineering. And I'm looking forward to this webinar.
Thanks, Deepak. And finally, we have Louis-Pierre Gravel from Robic in Canada.
Thank you very much, Ben. So as Ben said, I'm Louis-Pierre from Robic in Montreal. I've been practicing for over 20 years now, which is quite a bit of time, and I've never seen anything like this COVID-19 situation. And I'm very happy to be able to give you some insight on what's happening in Canada and how we're dealing with this situation. Thank you very much, Ben, for putting this together. I'm looking forward to this.
Great. Glad to have you all here. So why don't we start out with discussing what official actions the various IP offices in your jurisdiction have taken in response to the pandemic. I'll start out with the U.S. and the guidance and notices have changed over time. We've received a few over the last 2 months. But really where things stand now is the U.S. Patent Office is closed to the public, still operational. As many of you know, the examiners in the U.S., a lot of them work remote. So for them, this is not a big change for them, but the office itself is closed to the public. Most of the prosecution deadlines in the U.S. have been or are available for extension right now. So it was originally through the end of April, and now it's through the end of May. So if you have any, most prosecution deadlines with a few exceptions. If the deadline falls between March 27th and May 31st, you're eligible for an extension on that. It's not automatic, but you have to submit a statement that you've been affected by COVID-19. The requirement for that is very broad. It could be whether you've personally been affected, your company, even your patent practitioner, if your law firm has been affected by it. And they've given examples of what that effect could be, and it's non-limiting, but that could be an office closure. Importantly, it could be a cash flow interruption in your business, inaccessibility to files or other materials, any travel delays, an illness by yourself, a family illness, anyone associated with the filing this IP. What it does not apply to is application filings. So if you have a foreign priority deadline coming up, a national phase of a PCT, those deadlines are not extended, but most prosecution deadlines are. We also have any hearings scheduled at the PTO are automatically now by phone and video. No in-person hearings going on. So that's where we stand here. Why don't we throw it over to Eric if you want to tell us what the EPO is doing.
Yeah, sure. For IP and patents in Europe, the central authority here is the European Patent Office. And as for the US, there has been a couple of updates since the first measures were taken in March. I think it was the last day of March where we first heard from the EPO. Currently, all the major offices of the EPO are open. A lot of the staff is working from home, but they say there is no reduction in the work being done, and all new and pending applications are being processed just as normal. In the latest update from the EPO, all time limits expiring after March 15 are automatically extended to June 2nd. So that is the current date. This goes for EP applications, but also for PCT applications, which are handled by the EPO, and also including payment of annuities. They also say that this June 2nd deadline might be extended further if the situation requires it. But there are some exceptions as for US. For example, the due date for filing divisional applications that does not benefit from this extended time period, and also filing written submissions before oral proceedings and so on. So there are some exceptions to the time extension.
Okay, yeah, you made me recall in the US with maintenance fees, those are subject to potential extension, although it only applies to small and micro entities. So if you're a large entity, a company with more than 500 employees, you don't get the extension under these provisions in the US. Eric, is there anything you need to do to take advantage of extensions in the EPO? Do you, like in the US, you've got to file a statement, or is it just an automatic extension?
It is an automatic extension, so you don't have to submit anything except fulfilling the act that you need to perform. I could also say there are also some legal remedies for due dates expiring before March 15. And those are for users that were located in some specific areas that were directly affected by disruptions due to the virus. For example, the Hubei province in China, Austria, France, Iran, South Korea is also one of those areas, and a few others as well.
Great. In your experience, are you finding any delays in the EPO? Are examiners responsive?
Well, no, I think that the EPO is currently running very well at the moment. Our firm, we handle a lot of cases, and the response from the authority is so far just the same as before the corona, I would say. The search reports and office actions, they're all issued at the same amount as before. And since we also use electronic communications, everything is working pretty smooth here.
Yeah, I think it's been the same in the US. I've had some examiner interviews, and I've been able to get in touch with the examiners pretty quickly, and it seems to be things flowing at the normal pace. Okay, why don't we move on here? Hans, can you tell us what the JPO is doing?
JPO is they're open and they're doing business, but and also they provide 4 different kinds of relief methods for the due date. So it depends on procedures and documents. So each procedures and each documents have different treatment. I mean, so some procedures and documents have 14 days due for the relief, and the other some procedures and documents have 2 months due for the relief. So it depends on the procedures and documents. So I recommend that if you have some filing and procedures and documents in Japan, it'll be better to discuss your Japanese associate. And then it sometimes takes quite a long time. So the better to discuss your Japanese associate with enough time in advance. Or of course, you can ask me for the specific documents. And then for US clients, one different aspect between United States and Japan is that when we file on venue response of section, we usually file amendment and arguments. I think in United States, if we say amendment, it includes amendment and also arguments. But in Japan, amendment and arguments are different documents, and then their legal status is also different. So, so it's kind of strange, but that's Japan's rule, and an argument is in the 4 different kinds of relief method, but amendment is unfortunately is not in the 4 different kinds of relief method. So we have to do something for amendment, and also JPO is thinking that we have to do something for amendments, but there is no legal basis, I think. So so JPO tried to do make a way for amendments. Is we call that individual request. So if you have any OA off-section response due in nowadays, we have to ask individual request to the examiner for that each cases. And then I assume that, and everybody in Japan assume that there is no specific way or fixed way, but if you discuss to the examiner for that special case, I guess the examiner will reissue the off-section again, and then the due date starts from the date he reissued the off-section again. So it means the due date will be extended automatically. But the result is like that, but the way how to do is little different. So we have to, really better to ask your Japanese associate for each specific cases.
Okay, so in that scenario you're describing where you make a special request to the examiner, is that, it sounds like the examiners have discretion on their own then to make those decisions if they want to give you more time?
Yes, so nowadays Japanese Patent Office announced a lot of notices regarding COVID-19 response. And then in my personal opinion, JPO is using the term flexible a lot. So they trying to give a lot of discretion to the examiners, and then make all the relief method flexibly. But one thing, one kind of different than United States is that working at home, working from home for Japanese patent examiners is not general and also natural. So usually all Japanese patent examiners went to JPO, physical location, and then they work there. So, but now they have to work from home, but it's not general, and I think they are not familiar with that. And also, for example, one kind of main reason is that JPO examiners cannot access JPO server or system from their home. So it means that and also they cannot bring unpublished documents to their home. So their situation, their working situation is quite limited. So JPO examiners cannot issue off-section from home. They have to go to the JPO physically to issue the off-section. And also when the applicants sent an email to JPO examiners, they cannot read the email from their home. They have to go to the JPO, and then they have to access the JPO's examiner's something special system, and then they can read the response. So it's very kind of difficult. So we need, Japanese associate need some more time in advance to contact the examiners.
Yeah, I imagine that can lead to some delays if they have to go to the office to check their email and see documents.
Yes.
But it's interesting to hear that how they have some flexibility in adjusting deadlines.
Yes.
The US is a little more formal. You know, I mentioned that date range where if it's between March 27th and May 31st, you get an extension if you say you were affected by COVID. Outside of that date range, there's other means. You can file a petition, but that doesn't go to the examiner. But if you actually miss a prosecution deadline in the US now and it's due to COVID, in a normal case, you'd have to file a petition and pay a pretty hefty fee. I believe it's about $2,000 right now. And currently they're waiving fees. So if you don't quite meet the requirements in that date range, you miss a date, you can file a free petition. And I imagine they're granting them pretty liberally.
Yes, correct.
So why don't we move on to Canada? Louis Pierre, can you tell us how the Canadian office is doing?
Yeah, so I think Canada has adopted a way of working that is more or closer to the European situation. Recently, some provisions were brought into the Canadian IP Act, giving the commissioner the authority to determine that a day is a dies non for the purposes of calculating deadlines. And so we've had three separate announcements, one covering the period from March 16 to March 31st, then a second one covering the period from April 1 to April 30, and then recently a third one covering the period from May 1st to May 16. All of this means that any deadline that fell between March 16 and May 16 is automatically pushed back to the next day where the office is open for business, which in Canada falls or in Quebec anyway, falls on May 19th because May 18th is a statutory holiday. The net effect is to consider this period as a really, really, really long weekend for the purposes of calculating the deadlines. So there's nothing you need to do. There's no request that you need to make. It's automatically prorogued, or you have the opportunity to file by May 19th, what would have been due within those days. And the office is going to accept it as if it was filed correctly at the right time. One of the things we are suggesting is that if you're leveraging these extensions of time, quote unquote, we think it's very useful for your Canadian agent to be able to document this as much as possible. So for example, if you're responding to an office action, it's probably a good idea to say, applicant is responding to the office action dated X. The original date for responding was Y. We're filing on this day because of the commissioner's notice that the deadlines are extended. The reason why we're suggesting that is because in 3, 4, 5, 10 years from now, when someone's looking at the file history, everyone's going to have forgotten what COVID-19 is and what it meant. And if there's due diligence or litigation or anything like that, no one's going to understand why these dates are working. So we're recommending that people document this as much as possible. In terms of the office itself, CIPO, or Canadian IP Office, has remained open for business throughout this period, meaning that they're processing mail, they're issuing office actions, they're issuing patents, and they're considering amendments or responses to office actions that are coming in. there was a 2-week period, so probably that first period between March 16 and March 31st, where the office was sort of reevaluating or figuring out how they're going to work remotely. And so there was a lull for that 2-week period where pretty much nothing really happened. Although from then on, we've seen that the office is back to a very normal pace of issuing correspondence and receiving applications and everything else. Another thing I can say, so the office already had some experience with examiners working from home. So there was some ramp up to get everyone to be able to do this, but now that's pretty much done for everyone. So you can have examiner interviews on the phone, that's fine. Patent appeal board hearings, are now being held online by video conference, whereas before they were typically held in person, although there was the option of having a video conference or a telco into the hearing. And that's pretty much it. So I would suggest that the general rule is that whatever deadline or is considered a deadline for doing business before the office, those deadlines are pushed back to May 19. Anything else and some wonky deadlines, like for example, the 1-year grace period for filing an application, those are not extended. And so you should be careful. Don't necessarily assume that everything's extended. It's not. There are some exceptions, and you need to pay attention to those little details. The last thing before we move on to Deepak, as I said, the office is open for business, although the days are considered dies non, which means that anything can be filed electronically. And we're also recommending that if you can perform whatever needs to be done before the office before the May 19th deadline, that you should do so. Thank you.
Just curious, Lupe, are you finding a lot of your clients taking advantage of this extension? I mean, being automatic, unlike the US, are a lot of people waiting?
No, we haven't found that a lot of people are waiting. In fact, we found that people are extremely hesitant to wait. And if we can get instructions or we can prepare whatever needs to be prepared to file in time, we're just going ahead and doing it. Very, very few are taking advantage of those extensions.
Okay. Yeah, I'm wondering if you're going to have a big flood of responses all due on May 9th, but it sounds like it's going to be pretty evened out.
Well, that's the big concern, right? So if everyone takes this extension, that means that May 19, everyone's going to have to work like 6 weeks in a day, which is probably not very feasible. So that's why we're recommending that people not wait until the deadline. I'm sure there's going to be some that are going to do so, but on the whole, we're not seeing that.
Yeah, similar to here, we haven't seen too many clients taking advantage of this provision. And I think you raised a good point with looking at the file history years from now. You know, the extensions are fairly automatic here as long as you put in the right statement. But, you know, I could see some questions coming up on whether they had the proper basis, whether there was a real material emergency due to COVID. So I think it's better to file if you can. But it's good to know that these extensions are available. So why don't we go over to Deepak? Can you tell us about the Indian Patent Office?
So I'll just give a background of this pandemic situation in India. So in India, the government of India imposed 3 different phases of lockdown. First phase started from March 25th to April 14th. The second phase started from April 15th to May 3rd. And now we are in the third phase, which starts from 4th May to 17th May. So officially, the lockdown in India is until 17th of May. Now, the difference between the first 2 phases and this phase is that earlier in both the phases, the office was completely closed. So no examiners, no staff was working in the office. Whereas in the third phase, government has asked the 33% staff to be present in the office and start the work. So while we didn't receive any kind of office actions or any notifications from patent office in the earlier two phases. Now we have started getting some office actions from the patent office. So effectively, the first two phases, the office was completely closed. And then in view of this scenario, patent office had issued notifications with respect to extension of due dates with respect to various activities related to IP. So, for example, now if you want to file a response to office action, or it can be payment of any fees that is due, or it can be responding to any opposition statement filed by any opponent. So, since this lockdown is extended until May 17, as per the official notification, the due dates for all these activities, it may be related to patents, trademarks, designs, and copyrights, all are automatically shifted or extended to May 18th. That is, once the lockdown is lifted. So, the official extended date in India could be May 18th. If we assume that further lockdown is not imposed by government, considering the scenario at that point of time. So, effectively, all the due dates that falling within this time period of from March 25th to May 18th, May 17th, the deadline is May 18th for those activities. Second important aspect that was notified by Indian Patent Office was with respect to the hearings that were scheduled in this during this period. The hearings usually in Indian Patent Office, the hearings are conducted physically as well as via video conference. So both these hearings, those were scheduled during this lockdown periods, have been cancelled, and the Patent Office will issue no new deadlines for all these hearings. So that they will officially, notify your agents, Indian patent agents, about the new dates for this hearing. As of now, they are not taking in hearings. In the third phase, as I said, 33% staff is working. They have started issuing the office actions and the notice of actions. And one more aspect I wanted to highlight here was, apart from meeting deadlines, there are certain documents, follow-up documents that you need to submit to patent office. That documents, there is a certain kind of timelines for those documents. Considering the COVID-19 situation, there may be issue with submitting of these documents to the IPO. So what they have done is they have specifically mentioned that you can file a petition for condonation of delay, and accordingly it will be considered, and you can file the documents as per the petition file.
Great, thank you, Deepak. So it sounds like it's similar to Canada, an automatic extension. So there's nothing you have to file together with it, or no statement you have to make to take advantage of the extensions?
See, effectively, if you're not filing any particular document within the due date, there is a separate form for that where you can record the reason for why you could not file within the due date. So we can specifically record on that form 30. It's called form 30, that due to notice from the patent office that automatically this due date has been shifted to a new date. We are able to file it on. So it will go on record. We can file a form 30 for that.
Okay, great. So why don't we move on to another question here? I'm interested in beyond the patent office, are there any other closures or events in your jurisdiction that is affecting your practice or the timeliness or the filing of IP or the enforcement of IP? I can tell you here a few things in the US. We have our Federal Circuit Court of Appeals that hears all the patent appeals. They are still doing business, but they're actually hearing all the arguments by phone right now. During the May session, that may change, but they're keeping the calendar as is and hearing everything by phone. The district courts, it seems that they're pretty much stalled at this point. I know in the federal courts kind of have different rules based on what state they're in, but here in Connecticut where we are, they've taken all civil and criminal hearings scheduled through June 15th off the calendar. And if you have a special reason you want to need a hearing, you can request one, and they'll take it on a case-by-case basis. Primarily in criminal matters where they have to meet a certain time limit. They're doing some of those in person, some by video, but I think things seem to have really stalled on the enforcement side. Another thing that's affecting us to some degree is typically with patent assignments when we have US inventors, although it's not required, we often get them notarized. And it's difficult to do that right now because that's an in-person event. So that's again state by state, but Connecticut is allowing notarization by video. So you can actually connect with a notary public over video, and as long as it's a live stream and they can see your ID and watch you sign it, that can still be taken care of remotely. So if any of you have any points you want to make on that, let's start with Eric. Is there anything you want to point out in your jurisdiction?
Yeah, sure. I could just say a few words also on the EPO practice in terms of oral proceedings before the opposition division and the boards of appeal. Previously, we had oral proceedings only available on video in special cases, such as before examining division, normally as a last stage of prosecution. But now there is a pilot program of also allowing oral proceedings before the opposition division on video. I think that's a great leap forward. But if you're not on the video pilot program, all oral proceedings before the opposition division, they are postponed also until the June 2nd day. And for boards of appeal, all oral proceedings are postponed. The date that is currently due is May 15, but that will probably be extended as well. With regards to your question, Ben, we haven't received any reports of any malfunction in the infrastructure, such as courier service or notaries and stuff like that. Especially when we validate European patents, some countries require a lot of paperwork to be submitted, but it seems to work just fine despite the strange situation. Some colleagues of mine they're doing court infringement proceedings just now as we speak in Sweden, all according to normal routines in the courtroom. And there are some Italian witnesses for that case that must attend the proceedings from home because the court in Italy is closed. I was summoned to an oral hearing in the patent court now in June. That will be made on video. And I spoke with one of the judges about that, and she confirmed that there were some technical issues that needed to be solved in order for her to be present from home. But otherwise, I could expect it to run as normal. And correspondence is working smoothly. I haven't heard about any single internet shutdown, and even for a short period of time, and no missing emails or other communications. So it seems to work pretty fine here.
Great, thanks, Eric. And I know some people are probably curious. We hear a lot in the U.S. news here about Sweden and how they're taking a different approach to the COVID-19 than they are in the U.S. Can you just give us a little bit of insight on that, how things are in Sweden? Are people going to work? Are a lot of people staying home?
Yeah, sure. I mean, Europe is many countries, and a lot of different measures are taken in different countries. It ranges from complete lockdowns in some countries to far less restrictions in others. And in Sweden, we have a very strong culture of individual responsibility. So the government, they have been pretty relaxed with their measures, leaving much of the responsibility on each person. So in principle, we have two major directives here in Sweden from the authorities. The first one is saying stay home if you don't feel well, which is pretty obvious, and we shouldn't meet with elderly people, especially the ones in nursing homes. So for example, I'm here at the office right now, and schools, restaurants, public transports, they are all open here. And I think we just have to see who chose the best strategy for the corona. But in Sweden, it's pretty relaxed. We have, for our firm, we have a Stockholm office. Stockholm has been, they suffered a little bit more than the rest of Sweden with regards to the virus. So everyone is working remote in Stockholm. But in the southern part, we are still at the office, at least some of us.
Okay, thank you. I just want to go back to to one question I had. We were talking primarily at the EPO. Are the individual patent offices around Europe fairly aligned with the EPO, or are there any examples you might be able to point out of them reacting differently to this? For example, the Swedish Patent Office.
Yeah, it's. I think everyone is more and more working from home. I think the EUIPO dealing with trademarks and design, I think they are all working remote at the moment, and the office is actually closed. In Germany also, I think they are all working remotely, at least most of them. So I think that's a trend, but they are still open and they are still available, and they deal with cases in normal speed, I would say.
Okay, thank you. Why don't we go over to Hans? Is there anything else going on in Japan outside the JPO that's impacting your practice, whether it's the courts, the mail system, anything like that?
Yes, Japan's court canceled all the due date except for certain urgent cases before May 6th, which was the first national emergency declaration day. And then Japan's government declares the second national emergency declaration, and it's now until May 31st. So I guess that Japan's court would cancel again all the due dates before May 31st. And also Japan's court, especially IP related parts, try to conduct oral hearings using video conference. Actually, it started from before COVID-19 status. And also they wanted to keep doing this after COVID-19 status. And also, and then when they do video conference, they usually ask the both parties whether one of them refuses video conference or not. And then as long as nobody denied or opposed the video conference, the oral hearing will be done by video conference. And even though JPO is open and they're doing business, they don't accept the documents at the physical counter or window in JPO in Tokyo. So we have to send or file documents by online or mail only. But when we send documents using patent post office, some parts of Japan's patent office, they reduced their business hours from 10 a.m. to 3 p.m. So it caused a little bit delay because they're working little. So, but they're still doing their business, and as long as applicants take enough time to do, it'll be okay. And I think other like private services like courier, FedEx, DHL, there are no changes. So we can use also that. And yeah, that's it.
Great, thank you. Deepak, before I turn it over to you, we've got a few comments that your mic was a little quiet. So if maybe you can move it closer to mouth when you talk. Can you tell us anything else going on in India that's affecting your practice? I believe I had heard that the postal service was at least partially shut down or delayed in India. Anything like that that's affecting your practice?
So during lockdown, the postal services as well as courier services were affected, not to the extreme level. So some the post office, General Post Office of India, Indian government was operational, but most of the courier services were not operational. During the first two phases of that. Fortunately, as far as IP is concerned, if the applicants are engaging any patent agents for filing their IPs in India, we have an electronic model where we can file these applications as well as submit the documents. So there is no need of any physical documents being submitted at patent office or IP office. all documents that we submit is through e-filing, and hence we, since agents were working from home and also the electronic model was functioning properly, we could submit all the documents. So there was no issue, the IP services were not affected as such due to courier services or postal services.
Great, thank you. Louis Pierre, anything in Canada outside of the Canadian Patent Office that's being affected?
Right. So, yeah, one of the things, and this is, and I have to be careful because I understand there are some people from the Canadian Patent Office and other Canadian government agencies listening into this webinar today. So I'm going to be very careful what I say. But the reality is that the Canadian office has been working on legacy systems for quite a long time. And they are in dire need of computer modernization. And so a lot of the firms in Canada still had as a practice to print out whatever needed to be printed out and then file it physically by paper at a local office of Industry Canada. Now, since the lockdown, all those offices are now closed. And although Canada Post is still functioning, my understanding is that the vast majority of offices have pivoted very quickly to filing just about everything online, which the Canadian IP office now allows. And so although there has been that disruption, if you want, from that point of view, firms in general and applicants as well have pivoted very quickly to filing electronically, which is great. And I think that's going to have a really long-lasting impact in our business. I don't see ourselves going back to printing stuff. For those that are still a little bit leery of using online services to file things, you can still fax them in. Yes, we still have faxes in Canada, and the patent offices or the IP office generally is adapted to receive those faxes. When it comes to the courts, similar to the United States, Canada has two separate parallel systems of courts. So the provincial courts in the various provinces, and also a federal court architecture that deals with federal law. The vast majority of IP cases are being handled at the federal court. My understanding is that they did suspend pretty much all activity for a period of time. But the court has also adapted very quickly to the situation and is now, as I understand it, contemplating trials being held remotely in the coming weeks or months. And so that also, I think, is going to have a significant impact on the way we do business in Canada with respect to IP matters.
Great, thank you. So I'm curious from all of you, do you see this pandemic changing the way that your patent office or practitioners in your jurisdiction do business going forward? I mean, we've seen a lot of changes that are temporary. What do you think is going to stick around after this is over? You know, in the U.S., we've got examiners working from home already. I don't think, I mean, that may increase somewhat. Louis Pierre, you had a good point about electronic filing. I think here, all our trademarks are electronic. Patent, you could still file by paper. Maybe our patent office will mandate electronic filing for patents. I think what I see is video hearings have been permitted in the past in video communications with examiners, but I think it hasn't been used that much. I think with all of us on Zoom on a daily basis now, we're going to be more comfortable with that, and that'll probably be a lot more of a common thing, especially when you have appeal hearings at the patent office. I often go down and argue those in person. Now they're offering those by video. I think that's going to become a lot more common, and we'll see less travel to the patent office going forward. Eric, do you see any of these changes sticking around, or any new policies being put in place?
Well, I totally agree with you, Ben. If I take my own firm as an example, meetings in person has always been the preferred option. And before, nearly all video meetings, they started with a few minutes of technical struggle, just making it feel as a bad way of working. But now we have big video meetings nearly every day, and people have learned how it works. So all software is updated properly, and there are no longer any technical issues at all. So, and at first some people were a bit hesitant to put on the camera, but I think most of the people has now realized that seeing the person you're actually talking to gives so much more energy to the conversation. So as we're getting more and more used to the video meetings, I think, and I do hope, that it will be established as an available option for all proceedings before the EPO. I also hope that the examiners will accept video meetings instead of simple telephone discussions during prosecution. And I think that could be extremely valuable during prosecution, when you can share your screen to discuss prior art relevance and patentability and show the product that is being patented and so on. So as these video options will come into play more and more, on a more macro scale, I expect that the firms in Munich, they will lose some of its default attraction for non-European applicants, because it will no longer be that important to be in a walking distance to the EPO office. So video is a major thing here for the future, I think.
Great, and you had mentioned the pilot program with EPO oppositions. If you know, was that intended to be temporary, or do you think if they will do that in the future and actually have contested proceedings by video?
Yeah, I certainly hope so. I haven't tried it myself, but I sincerely hope that this is just to try it out, and then to have it also for the future. But we'll have to see about that. I'm not really sure actually what the plans are.
Yeah, we'll see how that goes in the US too. And we have PTAB hearings where you're appealing a patent. I think it's easy to do there, but when it's a contested hearing and you've got an opponent, it's a different dynamic. We'll see if that comes into play. Hans, do you see any changes that'll be permanent in the JPO or in your jurisdiction?
You know, I cannot guarantee, but I guess the JPO will change something in the future, because, for example, video conference and video interview with the examiner. We could do video interview with the examiner before COVID-19 situation, but every time we did video interview, the examiners were in the JPO physically, and then applicant side were in law firm or their company. So, but after this pandemic, many of Japanese patent examiners are working at home, but that they cannot do video conference from their home. When they do video conference, they have to come to physically to JPO, and then we did video conference. So it's very inconvenient. I think JPO will notify this inconvenience, so they will do something, but there is nothing announced yet. So we hope, but we actually don't know.
Yeah, it'd be nice if they loosen the restrictions on the examiner so they can work from home and actually access their files and
yes.
video.
Yeah, it's very, the examiners working from home, they cannot access the system, they cannot access the email server, and also they cannot bring the unpublished documents from JPO. It's very good for protecting the secret information, but right. It's kind of too inconvenient.
Yeah. Thank you. Deepak, do you see the Indian Patent Office making any permanent changes going forward?
As I mentioned earlier, if you are engaging with a patent agent for filings in India, so all the filings have to be mandatorily done through software. So there is an electronic model. You have to submit it electronically. So this approach has already been adopted by patent office, and it's functioning from last 2 to 3 years. And there has been any change with respect to these filings. As far as hearings are concerned, examiners who conduct physical hearings at their offices, as well as video conference. So it is at the examiner's discretion to schedule a hearing, whether it is a physical hearing or a VC hearing. So going forward, I believe that considering these kind of situations, they may switch to video conferencing hearings. All the hearings will be conducted through video conference. This is one change that I can see as far as operations. And I mean, these hearings are for grant of patent. If there are opposition proceedings, obviously the physical hearings are preferred by examiners because both the parties need to be physically present at the patent office to discuss the case and completely discuss the case. So there can be a scenario that patent office might think that they can also switch to VC for opposition proceedings as well. But as of now, I don't see that change.
Okay, thank you. Just to point out, we still are getting comments as your audio is quiet. So if you can maybe get your microphone a little closer. Louis Pierre, do you imagine any more permanent changes in Canada due to this?
You know, it's funny you should ask that question. I'm involved with the Intellectual Property Institute of Canada, which is the equivalent to the AIPLA or to various other organizations representing practitioners or people interested in IP, and acts also as a voice with the government to try to address some of the issues. And one of the issues that we've been pushing the government to act on is the acceptability of electronic signatures. And before COVID-19 hit, there was very little appetite at the government level and CIPO in particular to consider the acceptability of electronic signatures. So not just a graphical representation of a signature on a document, but the types of DocuSigns or eSign Live or other online verifications for signatures. All of a sudden, electronic signatures are accepted for the purposes of registering assignments or powers of attorney or other documents before CIPO. We are hoping that this is going to have a lasting effect and that we will be able to continue using or having or submitting documents that have been electronically signed before the IP offices, because it just makes a lot more sense. And you were talking about notarization and legalization of documents also. I think a situation like COVID-19 has painfully illustrated how these requirements really don't fly very far when the world is in a lockdown situation. I also think that communicating electronically with the various offices is going to be what's going to become the de facto standard. I also believe that communicating with examiners is going to move away from traditional telephone dialing to the examiner to video conferencing once the appropriate infrastructure and systems are rolled out to all of the examiners. I think even for us on this call and listening into this presentation, the way that we interact with our colleagues around the world is going to be very different from what it was in January or February 2020. And that also, I think, is going to have some lasting impacts.
Yeah, that's a good point. You and I had talked about that previously. I think interacting with colleagues around the world and in events like INTA, that's kind of all in flux now. I think, at least for the time being, we're all going to be traveling a little bit less and using platforms like this more.
There is a question that I don't know if you want to address now, but it's from someone who asks about how does the pandemic impact on the economic activity affect patent filings from all applicants, not just startups or corporates or academic institutes. And so did you want to address that now or a little bit later?
Yeah, we could talk about that now. I can comment on it, but if you want to, why don't you go ahead? Do you have any thoughts on it?
I have lots of thoughts on it.
Please go ahead.
So there, I don't know, there's probably everyone here is relatively active on LinkedIn, and I think you might have seen these graphs that illustrated the impact of the 2008 financial crisis on patent filings. And I think we're going to feel something very similar this time, which is there's a delayed impact on the new filings. I think all of us recognize that we have a lot of stuff that's in the pipeline right now that needs to be addressed. And yes, we can get some extensions to the beginning to the middle of May or beginning of June or mid-June, but those extensions are not going to be forever. And so there's work that needs to be done, unless of course there's an exercise in pairing the portfolios from the various applicants. But you've invested a lot of time and effort into filing these applications. You're at their first, second office action sometimes. You want to go forward. So there's a lot of stuff that is in the pipeline that needs to be addressed and processed. I think we're going to see a drop in filings probably in 6 to 12 months from now. And that may stabilize a little bit afterwards, depending on how fast the economic outbreak or the impact on the economy stabilizes and comes back to more normalized levels. So I think that's what collectively we need to be aware of for the patent sector. I think the trademark sector is much more sensitive more quickly to a slowdown. Marketing, launching new products, things like that are the first that are on the chopping block. And those I see will probably pick up before or at the same time that the patent filings are starting to drop off. But that's just, you know, my crystal ball gazing from Montreal, Canada, and you know, my crystal ball is no better than anyone else's.
No, I agree. I think we will see a drop in filing, and I think just talking to various clients, you know, a lot of companies are disrupted now with their employees scattered. Some are being affected economically and kind of in survival mode. So, to your point, a lot of people are maintaining what they have, but maybe not thinking as much about new filings. And I noticed that question mentioned startups in there as well. And I you know, I think I've seen with some smaller clients where they just don't want to proceed, or they need extra time because they're very crunched by this economic crisis. So affecting companies at all different levels in different ways. But I think, you know, we will see a drop in filing over the next few months.
We could probably think about another webinar where we would be looking at the various financial incentives that governments are putting into place to support the innovation aspect of the various economies. Because that also, I think, is a very interesting topic, and it ties into IP policy from a national perspective. And it ties in also from being able to help the startups and the academic institutes in continuing the important work that they're doing in innovating and driving new products and services to market. But that's an idea for another day.
Yeah, we'll have to get that on the schedule. Does anyone else have any other comments about how they see this affecting the filings for startups or all types of companies?
I'd say we see the same here in Europe and in the Northern Europe. We have big automotive companies. I think the new filings are low at the moment, and some other industry sectors are running as normal. But on a general level, I would say it's the same as you and Louis-Pierre described.
Great. Anyone else? Hans, do you want to chime in on that?
I think it's not only for the startup companies, but for example, my firm has a policy to draft a patent specification. Every time when we draft patent specification, we have to do in-person interview with the inventors, because in that way it's very good. We believe it's good to catch all the thought from the inventors, and then we can draft better specification. But now we cannot do in-person interviews. So video conferences is not very common in Japan, I think. But now we are trying to do more video conferences. And also my headquarters in Tokyo is an big unit which has like more than 200 people. But we thought that having more than 200 people in the same places is kind of dangerous for this kind of situation. So we decided to make satellite offices, a lot of satellite offices in Tokyo. So we plan to open around 10 offices in Tokyo, in whole area. So we cover all the Tokyo area, and our employees can work anywhere in Tokyo, close to their houses. And then if something happens, we can, change our offices. And then, as Ben said, it's kind of survival mode. So, sometimes if we know an actual patient of COVID-19 in certain building, sometimes the building itself is locked down. So if we have all employees in the same place, it's very dangerous. So we can do that kind of relief method. And yeah, that's it.
Great. Thank you. Deepak, are you seeing or forecasting any drop in filings in India? Okay, it seems you may have some audio issues. We can move on. So it looks like we're kind of getting towards the end here. I thought maybe we could all just I'll give you all a few minutes if you want to do a wrap up, and any key points you want to highlight, any recommendations you have for our clients here in the U.S. or anywhere, anything they should consider at this time that's important for them to know about filing in your jurisdiction. Where can we can start? Eric, if you want to chime in with any wrap-up comments.
Yeah, sure. I think to sum up, the patent practice is doing quite well in Europe still, and I see no official or general reason for precautionary measures by applicants at the moment. But I fully understand that for some applicants, the available extensions that are now the EPO now allows, they can be very useful, and the EPO fees are quite high, and we now have the possibility to also to push those payments a bit forward. But if you consider doing that, you should just make sure to double check, because there are some exceptions, as I told you before. And re-establishment in Europe is quite tricky, and it's certainly not an easy win for lost cases. And I also think that the June 2nd date, well, my best guess is that it's probably going to be extended for some additional time, but we'll have to see about that.
Great, thanks a lot, Eric. Hans, any final thoughts?
Yeah, sure. As I mentioned previously, JPO examiners are working from home in limited condition. For example, I said, they cannot access the JPO system. They cannot read their emails. So it means that it takes time to contact JPO examiners by JPO associate. And so I guess the most important thing for US applicants and any other applicants in the world about Japan is that contacting your Japanese associate in advance with enough time is better. And also Japanese patent office is responding this COVID-19 situation very flexibly. As I said, they are mentioning flexible a lot of times. So if we contact JPO examiner with specific cases, and then if we discuss that cases, I guess JPO examiners will do certain relief. So the most important thing is that having enough time in advance and discussing your Japanese associate with each cases in advance.
Great, thank you. Louis Pierre, any comments in closing?
Yeah, I think similarly to some of the situations in Europe and Japan, um, I would not be surprised if the commissioner extends deadlines one more time, probably to the beginning of June. I think that's very much in the realm of the possibilities. Um, just to give you an example, the province of Quebec is aiming to reopen some of the schools next week and the week after on the island of Montreal. That is highly dependent on the numbers that we see in terms of hospitalizations and infections in the province. If things don't go as planned, we can expect to see some pushing back of those dates. And since the patent office is physically located in Quebec, then we could certainly expect that there would be some pushback on that point. I think my recommendation, as I mentioned earlier, if you can act before the office by a certain deadline that is stated, I would recommend that you do. If not, we can always look at benefiting from those extensions. Those would be the two main takeaways I would think.
Thank you. I know Deepak was trying to get his audio reconnected. Can you hear us? Okay.
Can you hear me?
Yes, we can. Great.
Okay. Yeah.
So yeah, Deepak, we were just in closing here. Do you have any final thoughts, recommendations for U.S. and other clients? Anything they should consider with respect to the Indian Patent Office at this time?
I would recommend all the US clients to meet the deadlines because since earlier, as I said, the electronic model is pretty much working, and almost all the documents are to be filed online, and also the filings are to be done online. So there is no reason for any delay. And of course, if in case there is issue with certain documents, we can anyways take extension from the patent office and file the documents separately.
Great, thank you. We can hear you loud and clear. So yeah, I'll just echo some of those same points. I think Hans said it best that the offices are being flexible right now, and it's a very fluid situation. The patent office in the U.S. is being flexible, and they're issuing new guidance every week or two. So right now we have deadlines extended through end of May. That very well may change. So I think for owners of IP portfolios out there, stay on top of the deadlines, keep in touch with your counsel. And if you need more time, it's available. There's a lot of flexibility out there. If you miss a deadline, there's ways, at least in the US, to get it back. Like I mentioned earlier, they're waiving petition fees. So even if you don't qualify for some of these extensions, if you just let things slide accidentally, there's ways to recover from that. So I know a lot of companies are in financial crunches right now, but before you go ahead and abandon cases, talk to your counsel, and there may be ways to push things out, get some flexibility, and think more long term. Not let things go now that you're going to regret doing years from now. So I just want to thank all the panelists. This was great. I really appreciate you all joining us. Thank you all the attendees for listening in today, taking the time out of your day. I hope you all got some value out of this. And the idea was to give you some insights more than you can read on these notices we're getting out there on what's really going on the ground in these countries. And I think we gave you that. But if you have any specific questions, feel free to email me. You can find any of the panelists on their website. If you want to send me an email, blehberger@Dilworth IP, I'm happy to answer any questions, and I can forward it to the panelists if you can't get in touch with them directly, and we'll handle any additional questions you have. I'll also point out that the USPTO, if you just go on their homepage right now, on the top banner, they've got up-to-date information, a specific coronavirus site. So they're putting all the latest notices on there. So it's good to check that occasionally. And WIPO just yesterday announced a new COVID-19 policy tracker. So if you just go to the WIPO homepage, there should be a link there, and they're doing a great job of collecting information from all over the world, all the member organizations, and trying to consolidate that. So if you have any interest in looking there, you can get a kind of a broad view of what's going on everywhere. So thank you all again. Just want to point out, check your email in the next few days. You should be receiving a recording of this so you can share with others that couldn't make it. And when you log off, you'll see a post-event survey. So I'd appreciate it if you could just take a quick look at that and provide any feedback you may have to help out with our future webinars. So keep an eye out for additional Counsel to Counsel webinars from Dilworth IP in the future. And thanks again, and have a good day.
Thank you.
Thank you.
Thanks, Ben.
Thank you, Ben.